So we are today going to talk about national security and privacy issues. We have an excellent panel for you. And some of the topics we're going to get into are cyber threats and government power, recent trends in data sovereignty, and the recent uproar over surveillance and data collection targeting reporters and congressional staff and lawmakers in leak investigations, or at least incidentally collecting on lawmakers while targeting congressional staff. And with us, we have three excellent panelists. So I'll introduce them in turn. First is Glenn Gerstel. He is the former general counsel to the National Security Agency from 2015 to 2020. So he had the interesting experience of bridging the Obama and Trump administrations for significant periods. He is currently a senior advisor in the International Security Program of the Center for Strategic and International Studies. The second panelist is Travis LeBlanc. He's a member of the Privacy and Civil Liberties Oversight Board and a partner at Cooley, where he's the vice chair of the firm's cyber data and privacy practice. He had been unanimously confirmed by the Senate in 2019 to the Privacy Board, the PCLOB, and he was previously the chief of the Enforcement Bureau at the Federal Communications Commission. And finally, we have Bob Litt. He's the former general counsel for the Office of the Director of National Intelligence from 2009 to 2017, basically the entire Obama administration. And he is currently of counsel and co-chair of Morrison and Foerster's Global Risk and Crisis Management Group, and is also an adjunct professor at Yale Law School. So let's dive right in with these three on the first topic of cyber threats and government power. So it's no secret that cyber threats have been a big problem over the past decade, and it's only getting worse. This is not just nation state spying activities like China hacking the US government's Office of Personnel Management files and Russia stealing Democratic emails in a hack and dump operation intended to help Trump win the 2016 election. It's also hacks targeting US corporations and doxing people, and ransomware, like the recent crippling of an oil pipeline by Russian hackers that led to gasoline shortages across the East Coast. And much of this malicious activity originates abroad. So my first question is to Glenn. Why can't the government stop this kind of malicious activity originating abroad? And what do you propose?
Thanks, Charlie. And first, it's thanks to you and my fellow panelists and to the conference organizers for creating this opportunity here. I think we're gonna have a great time. So your question is absolutely right, and your points about cyber maliciousness getting worse, probably before it gets better, are absolutely correct. You talked about a wide range of cyber maliciousness, and our policy responses to it are going to depend upon the source and type of this maliciousness. It runs the gamut, as you indicated, from surveillance by foreign governments, which often isn't publicized and is kept quiet, to far more noticeable in public criminal activities, ransomware, mischievous attacks, stealing credit card information, intellectual property, et cetera. And along the way, there's preparing the battlefield for potential cyber war in the future, stealing information for strategic purposes, such as we see China do. So our responses will vary, but we can solve this problem. And I think there are four particular points I'd like to make. I know we could talk all day about it, but let me just mention four. First, technology is not standing in the way of this problem, standing in the way of our solving the problem. It's hard, it's expensive, but political will and social will to fix this are what's standing in the way, along with the lack of expertise and a number of other factors. We can talk about that more in the Q&A, but it's not technology that's holding us back, it's other factors. We can solve this. Second, focus on more cyber offense, on more international sanctions, more international cooperation are all good steps, and we should be taking them, but we're kidding ourselves if we think that alone is going to solve the problem. What will make a big dent in the problem is getting the kind of information and ability to get that information quickly about hacks and attacks currently underway so that we can stop them in their tracks will be what's effective in ending this plague here. Right now, I think our approach has to be to recognize that we cannot stop incursions. A sophisticated adversary is going to get in your computer somehow, but we can limit their effectiveness, we can stop it from spreading. One way we need to do this, in my final fourth point, is that we need to close the gap in our legal architecture, our pre-cyber architecture. Our foreign adversaries are aware of this gap. They know that there's no government authority, there's no government agency that has a general domestic cyber monitoring authority. I'm not suggesting that we should have one, but there is a gap there, and our foreign adversaries take advantage of it. They legally hire and rent out virtual servers or real servers in the United States and use those as a launching pad, as a staging ground to undertake their cyber maliciousness against American computers, both government, business, and individuals. So right now, just very briefly, when the NSA, my old agency, found out about cyber maliciousness that was occurring on the United States soil, we handed that off to the FBI, who, with a bit of luck, was able to get a search warrant if they had probable cause. It would take a few days, or maybe do some less intrusive action. But in any event, by the time they got around to doing it, and they were doing it as quickly as they could, the adversary, China, Russia, Iran, had already jumped and was moving elsewhere. So we need to have a new authority granted to the FBI, which I believe is the right place for this. I advocated this in an article in Politico a few months ago, a new authority for the FBI to engage in hot pursuit, where they have specific information about foreign malicious cyber activity that has come on shore to injure us. We can have all sorts of privacy and civil liberties safeguards built into this to make sure it doesn't run off the rails, and we have great experience in providing adequate privacy and civil liberties protections. We can limit this authority to just 72 hours. It can require certain kinds of approvals. It can be overseen by the Department of Justice or the Foreign Intelligence Surveillance Courts. We can put limits on the kind of data it's needed. The data would be it could be collected rather, and require that the data be deleted promptly, et cetera. So we can have a whole suite of protections. And what this would enable the FBI to do is see an attack as it is occurring and be able to prevent it from spreading, because they'll be able to see what other computers the Russians or Chinese or whoever are going after and stop it in its tracks. That will make a big dent, and there's a way to do this. The alternative of doing nothing is to let these foreign adversaries run through our American computer architecture, and that's not acceptable.
All right, so Glenn, your comments talk about a way in which there's a blending between foreign-based malicious cyber activity and domestic, which is when foreign actors use US servers and attempt to evade basically border monitoring by the NSA. And so that's a good bridge to me to turn to Travis. Travis, what is this? Glenn is confident that this could be done in a way that protects civil liberties and privacy. What's the critique of his proposal, and what would this mean for actual domestic hackers and other threats emanating from Americans on American soil?
Well, first of all, thank you, Charlie, for moderating our session today. And thank you to Wirewheel for inviting all of us to participate. I'm excited to join Glenn and Bob and you, Charlie, in today's conversation. In answer to your question, I think Glenn's proposal primarily focuses really on nation-state-backed or foreign-backed threats rather than domestic. Domestic-based threats present a whole series of constitutional issues that make Glenn's proposal a little bit more challenging to move forward with. I want to start off kind of with the thought experiment of how to more effectively enhance the ability of the U.S. government to assist the private sector and individuals really with protecting themselves from cyber attacks. I will say that I am weary of wanting to provide NSA in particular with such open access to U.S. networks in the absence of judicial oversight. I do tend to share a view that one of the limitations that the private sector has in responding to cyber attacks is the inability to use offensive tactics without beginning to run into legal impediments, violating criminal laws such as the Computer Fraud and Abuse Act. There, to me, there does seem to be a role for the U.S. government in taking a more proactive, offensive role in protecting the United States, its businesses, and its people from foreign nation-based cyber attacks. Unfortunately, in my view, over the years, the FBI and the NSA have shown consistently that they are limited in their ability to police themselves when engaging in warrantless surveillance. Warrantless bulk collection, even of IP addresses or metadata, will necessarily lead to privacy and civil liberties harms. And we have to really, I think, rethink the collect it all approach, which has limited utility to prevent cyber attacks. Indeed, if we were to use the proposal that Glenn sets forth, really in a Political article, and he summarized here, or a collected of all approach, this wouldn't have helped prevent SolarWinds or other zero-day exploits. It wouldn't solve ransomware attacks. It wouldn't solve attacks where a company signs or approves the cyber attack. There are better, more proven ways to prevent cyber attacks, both foreign and domestic. What might those be? Patching, firewalls, zero trust framework, multi-factor authentication, backups, educating the public, educating industry on the need to take these proven, improved efforts to overall augment our cybersecurity posture would be a better way. We all know that about 85% of networks are owned in the United States are owned by the private or operated by the private sector, not the government. Now, interestingly, there's 15% or so that's left by the government. And I do think there's a real role in whether it's the NSA or the FBI, paying a little bit more attention to, or DHS, paying a little bit more attention to government networks and the activity that's taking place on those government networks, because we might be able to use that in many ways as a canary in the mine to sort of highlight issues that may ultimately end up impacting the private sector. And SolarWinds is one example where the United States government was a victim, but it was not the only target or even necessarily the direct target of it. It was a much broader attack based, nationally and even potentially globally. But I do find it hard to see how packet sniffing is going to help identify many of the challenges that we faced. Just last week, Microsoft discovered a cyber attack, alerted the government yet again, and is working together with the government to address it. This public-private partnership, public-private information sharing is a step in the right direction and does appear to be a model that could help us. Unfortunately, in the past and for years, the executive branch has really been thinking about how to do cyber information sharing and to make it work. So, at best, I kind of believe this approach towards allowing the NSA, in particular, more insight, really, even in its best scenario, only helps against large-scale nation-state attacks and really isn't going to help with the core threat vectors that lead to cybersecurity incidents. I hate to say that in thinking about the response to cyber today, we don't want to develop a 2001 response to cyber that today doesn't reflect an understanding of the 2021 cyber threat, which is both nation states and non-nation state actors, some of whom are in the for-profit business or hired by nation states to do things, some of whom are really, I hate to use the term lone wolves, it would be the sort of best term to use them, independent folks who are able to identify a vulnerability to just wreak havoc with no particular mission or necessarily a track record of having done it in the past.
Let me jump in here, Travis, because I'm sure that Glenn's going to want to respond, and you may want to respond to him, but also we want to get to our second and third round as well. So just to pick up on one strand, you raised that, especially when dealing with domestic-based threats, there's constitutional issues, legal issues that may run into any government packet sniffing technology of the sort that Glenn is proposing, primarily, as you noted, in the foreign nation-state adversary context. Can you develop that, Bob? What are the legal issues here that would be raised by this kind of proposal? And in particular, would automated scanning of internet traffic in search of signatures of malicious code constitute a search under the Fourth Amendment of the sort that either would be reasonable inherently or require a court order?
So let me approach this, take a little bit of a running start to approach this, and start by saying that, at least from my perspective, there's absolutely nothing inconsistent between what Travis is advocating for and what Glenn is advocating for. In the same way that You protect your house from burglary by locking the doors and having a burglar alarm, but you also rely on the police to be patrolling around the block, to be conducting criminal intelligence activities. I think we need the same approach here. There's no question that the private sector needs to be more engaged, but I think that the government provides capabilities that no one else has. And with due respect, I disagree that the NSA is only useful against large nation state attacks. Speaking hypothetically here, because I have had access to classified information in the past, one could imagine that there are a couple of ways that NSA could get information about potential attacks. One of them is by sitting on foreign networks and watching the communications that foreign actors are having and learning what their plan is. But the other is to be sitting on US networks. I am confident that NSA has signatures for thousands of attack vectors, and watching for those as they come in. And that's the part that I think presents the interesting legal issue, which is you can imagine that it would be a contributor to cybersecurity. It might not be the panacea, but it would be a contributor if NSA were sitting on networks all over the United States, looking at all the traffic in and out and looking for these threat vectors. And the question that Charlie adverted to does that violate the Fourth Amendment? And there are arguments both ways on this, and it's not settled yet. One can argue that if all you do is you have automated processes and no human being ever sees anything except under the circumstance where it pops up as being malware, there's really no invasion of privacy that invokes the Fourth Amendment. I will confess, that's a position that I've advocated in the past, among other things, in an article in the Yale Law Journal Online about half dozen years ago. The other argument, which has been made, for example, in litigation in California about the NSA's PRISM and Upstream surveillance programs, the other argument is that it is a search anytime the government is, through whatever means, essentially scanning the content of all communication. We know right now that the Fourth Amendment is in a bit of flux, thanks to the Carpenter decision, which on one reading of it sort of upends the traditional view of what is and is not a search. But I think that to the extent we want to make use of these probably best in world capabilities that NSA has, we're going to have to work through that legal issue.
All right. I think we could circle back to this, and we might during the Q&A session, but to move briskly through the topics that we want to get covered here and still have time for questions, let's move on to data sovereignty. Very briefly, I'm sure most of this audience understands already, but for those who don't, the architecture of the internet poses a challenge to the notion that countries can regulate within their own boundaries. Cloud computing means that data concerning country A may be stored on servers in country B, and this raises unresolved questions about what the rules should be for accessing or blocking access to that data in either country A or B. And some countries are trying to mandate that their people's data be stored on servers inside their national borders, either because they want to avoid spying by the United States. So many of the world's servers and cloud storage situations are in Silicon Valley, or because they want to be able to better spy on their own citizens' data, or both. So first to Glenn, can you walk us through some of the recent trends of national regulation of the internet and data usage and storage in this space?
Sure, Charlie. Well, like most technologies, there's an initial fascination with them, and then as we discover their risks or the misuse associated with them, there's a sense of vulnerability and reliability that we place on these new technologies, whether it's radio or electricity or the internet. There's a swing of the pendulum towards regulation. We certainly saw that with radio in the 1920s, for example, and the desires for greater control and regulation and content. The internet is no different. We're seeing a shift from forces propelling globalization to ones favoring fragmentation, or the splinternet as it's called. And this manifests itself in several ways. And I just think three at least warrant attention right here very quickly. First, in contrast to the general feeling of the wonderful aspects of the internet that were manifest in the 2010 Arab Spring, we've seen for the last few years authoritarian governments insist on greater content control and surveillance ability. That ranges from national firewalls that we see in China, Russia, Turkey, Saudi Arabia, et cetera. And this is beyond just banning websites. And by the way, in a country like China, we're talking about a very serious level of banning some of the world's most popular websites, whether it's Google itself, Facebook, Amazon, Twitter, Instagram, you name it, they're all banned in China. And so it's banning websites, monitoring activity, which is certainly done in China. And then another thing we are seeing increasingly in authoritarian governments is localized data control, insisting the data that relates to countries, that relates to citizens in this particular country, has to be maintained, analyzed, processed, stored in that particular country. We're also seeing limits on encryption. There's been a lot written about Apple's tussles with the Chinese government over the keys to encryption and what level of ability the Chinese government will have to see encrypted messages and VPN tunnels and so on and so forth. Sometimes this is all done under the guise of privacy. A perfect example of that is China's proposed new personal information protection law, which is modeled after European statutes. It has some good things in it, like requiring consent on how your data is being used, but it doesn't really apply to the government and has huge holes in it that would allow the government to undertake a continued surveillance. The second point, especially in Europe, where there are different notions of privacy, after the Snowden disclosures and the Schrems decision, which my fellow panelist Bob Litt was very much involved in the American response to, we're seeing a general push throughout the European Union on more aggressive regulation of social media, the digital world, well beyond the GDPR, the General Data Protection Regulation. And how this will affect the worldwide internet and the global applications and the large platforms is yet to be seen, but we're seeing a very concerted European effort in this regard. And then finally, thirdly, just a general backlash against big tech. We see this in the European Union, in the United States, even in China, which has its own antitrust approach, proposed antitrust approach. We're seeing this in the United States with Congress full of ideas on curtailing for antitrust reasons, big tech, the efforts to look at the Communications Decency Act, Section 230, which gives an immunity shield to social media platforms. All this is under great scrutiny. I think one of the defining issues for the next several years will be this balancing of globalization forces that look for efficiency and functionality and innovation and fewer restrictions on technology, and versus national efforts to regulate for both benign and nefarious reasons. Right now, in my opinion, the latter is in the ascendancy, but I wouldn't rule out the ability of big tech to outmaneuver, so to speak, and out-innovate some of these regulations. So I think this is going to be a very fluid, very dynamic debate over the next several years for all societies.
That's great. Thank you, Glenn. Let me turn to Travis again. In introducing this segment, Travis, I mentioned that a lot of data sovereignty issues have arisen in other countries, effectively targeting the United States, since so many cloud servers that service the world are physically located on American soil. And is that still the dynamic we're seeing as a piece of that question? What should the US government be doing, if anything, in the space of data sovereignty?
Thank you very much, Charlie. Very good question. And right before I turn to it, I just want to note that I enjoyed Bob's comments a few minutes ago. I hope the crowd, if it's interested in hearing more about the Fourth Amendment, will ask us some questions about it, because I'd love to have the opportunity to speak further about it. On data sovereignty, I agree with Glenn that there's a fluid and dynamic debate that's taking place, and I share several of his observations about the state of data sovereignty. In particular, I think many of us agree, if not all of us agree, that a balkanized internet is likely a bad internet. It preserves authoritarian tendencies. It decreases transparency, accountability, and freedom of expression. It breeds inequality. And from an economic and business perspective, it increases the burden of regulations and non-standard protocols, thereby increasing and introducing unnecessary friction into the internet ecosystem. In my view, many, in particular on the issue around localized data control, many of our competitor countries in the world are introducing localized data control, while we in the United States do not. And what is the implication of that? The implication of it is that for a U.S. enterprise to gain access to information about individuals in other countries in the world, we have to meet their requirements to access that information. But in the United States, we don't have those requirements. They're largely missing. And so our data is free and available to everyone in the world to do whatever they would like to do with it. There becomes a point at which we have to ask the question, as a matter of competition, as a matter of national security, what protections do we need to put in place to ensure the value of our data and also to protect the privacy of the individuals that are in the United States? I'm hopeful that we can begin to have a serious conversation about that at the federal level to begin to really recognize the competitive disadvantage, the privacy and civil liberties disadvantage, the national security disadvantage that we're at when there are no limitations on access to US data. And on the flip side, there are substantial limitations that we're seeing arise across the world.
Thank you. All right, well, I'm going to flip to Bob for a different topic here. This is the question of the privacy protections for reporters' data in leak investigations, which is currently in the midst of a revolution. For the last multiple administrations under both parties, it has been lawful and permitted under Justice Department regulations under certain conditions, which wax and wane, to go to Verizon or AT&T or Yahoo or Google and get the data of reporters without telling them ahead of time to try to figure out who their confidential sources are as part of a criminal leak investigation. But recently, after the Biden Justice Department disclosed that the Trump Justice Department had secretly seized phone records of reporters at the New York Times, the Washington Post, and CNN, and had also fought a court battle to seize their email records that led to extraordinary gag orders imposed on New York Times and CNN executives in a fight that spilled over into the Biden era, President Biden declared that he would not allow the Justice Department to use a compulsory legal process to go after reporters' records anymore in a hunt for their sources in leak investigations. And Attorney General Merrick Garland is now drawing up a new regulation that will apparently forbid this practice, which would be a sea change to how things have worked in the 21st century, including under President Obama and not just Trump. There are still some open questions here. What will count as a leak investigation to which this shield applies? Will it count a government official deciding the public should know something and talking out of school is clearly a leak? But what about an outside hacker who hacks into a government network and provides information to a reporter? Will reporters' records be protected if the FBI thinks that's what happened? Or what if the FBI thinks the reporter's source is a foreign agent? These are tough questions. And another question is, who will count as a journalist to whom these protections apply? Obviously, someone at the New York Times, I hope, would count, but what about a WikiLeaks style group? Or what about a group like RT, the Russia Today propaganda network run by the Kremlin that looks like a news network, but may not function quite the same way that the New York Times do? So these questions are open, but it is clear that no matter how they are answered, something fundamental is shifting right now. And as an investigative reporter, you can imagine what I think about all this. But I think it might be more interesting then to go to Bob as a former prosecutor and an intelligence lawyer who dealt with legal policy issues related to leaks of national security secrets in your government career. What's your take on this new bright line rule that the Biden-Garland team has announced when it comes to reporter data and the larger issues at play?
So I think this is a very difficult issue. one part of it is not difficult. Under the law, as it has been established in numerous cases, there is no legal protection for reporters in this regard from subpoenas to themselves or to third parties seeking information about them. That's been repeatedly decided and is pretty firmly settled now. So the question is really a policy one. What should the Justice Department be able to do? I start from the proposition that leaks can frequently be significantly damaging to national security. Not all of them are. The government does have a tendency to overhype the damaging effects of leaks. But I know of situations when I was at ODNI when we could see the reflection of leaks causing changes in behavior of our adversary. It's impossible to tell what information we didn't get as a result of that, because by definition, we didn't get the information. But I start from the premise that there is a national security cost to allowing leaks, and moreover, that a society really can't function properly if every individual takes it on himself or herself to have the authority to decide, well, I think that even though this has been properly classified in accordance with the law, I think it ought to be released. That's not the way a lawful society should operate. Now, having said that, that's not the reporter. The reporter is publishing information that somebody else has given them. And the reason for going after the reporter is never, and I'm pretty emphatic about that, certainly in recent years, never to actually prosecute the reporter, simply because whether or not the law would authorize it, the political consequences of prosecuting a reporter would be overwhelming. I mean, if you look and see the way the media lined up behind Julian Assange, as soon as the investigation of him changed from a hacking charge to a publication charge. So I don't think the question is, to what extent should the government, as part of a leak investigation, be allowed to either directly from the reporter or from third parties be able to get information about that reporter's communications to try to identify the source? And this is clearly a useful tool in a leak investigation. Leak investigations are hard. There are always far more people who had access to the information than the government initially believes. And it's very difficult to identify who the person is who leaked this to the reporter. And one obvious solution is to try to get information from the reporter. So having said all that, which is the argument for allowing these, this may be one of those areas where the benefits for law enforcement and national security do not stack up to the political consequences. The fact of the matter is that there haven't really been that many leak investigations that have been solved by getting data from or about the reporters. So that as a practical matter, the Department of Justice may not be sacrificing much by saying, we won't do this. As you know, Charlie, there are going to be some interesting line drawing. I have no idea how the department is going to determine who is a reporter and who is not a reporter. And in fact, there's a respectable legal argument that the government has no business making that decision at all. But that then leads to the question of, okay, who is it who's protected from subpoena? I would be interested to see what Attorney General Garland comes up with in this regard.
Definitely. Well, so let me please invite the audience, if you have questions you'd like me to ask this panel, use the Q&A function to submit them. And none have been submitted yet, but I'll see them as they come in. And in the meantime, let me go back to the first question we were talking about, where Glenn, Travis had some critique of what you were saying, although Bob seemed to think they could both approaches could be pursued. Let me ask you, what's your response to his rejection of your proposal of expanded government authority to monitor the network in search of malicious code activity?
Sure. Thanks, Charlie, for the opportunity, and also to both Travis and Bob for their comments and response. It's one of those situations where I'm tempted to say they're both right, which is to say that, look, the points that Travis made about the fact that there are many, many other alternatives open to us to stopping cyber maliciousness is absolutely accurate. He ran through a long list of things, whether ranging from more backups to better private public partnerships to increased security in the form of zero trust architecture, et cetera. That's all accurate. We've been trying to do that for years. It has not been successful, completely successful, partly successful. We need to redouble our efforts in that regard. But I think Bob's point also is accurate too, and I take some shelter in that, which is that I think both Travis's comments about what other things we can do and my proposal are complementary. I don't see them as mutually exclusive. I was focused on a particular, very pernicious type of activity, which is foreign malicious cyber activity that we cannot now effectively stop at our borders. That is not going to solve the entire cybersecurity problem. I do not purport that it will. It's not going to stop so-called zero-day exploits, bugs in software that nobody's ever heard of before. But it will make a big dent in criminal ransomware activity as it starts to spread from the first victim to the several hundred other victims. And it will make a big dent in foreign intelligence operations as they sniff around our networks. So again, it's not a complete solution. Cybersecurity is a function of many, many vulnerabilities. Bob pointed that out too, as did Travis. And we need to throw everything we've got at it. And one of the things that one gap we need to fill is this gap in our legal architecture that predates the cyber world. No surprise, but it's a big gap, and I think they can be harmonized.
Sorry, I was muted. And I do have a question here, but before I turn to it, Travis, you had also indicated a desire to talk a little bit more about the Fourth Amendment issues. Could you briefly hit that note, and then I'll go to this question?
Yeah, I'll respond very briefly. First, I should say that I do believe that if the NSA or other government agencies have classified information on ongoing or upcoming cyber attacks, they should share that information with the private sector. I think one thing that's absolutely critical is not just leaving it in the hands of the government. Now, that being said, Bob did open the door to me by speaking hypothetically about hypothetical collection activities in the United States government. And I would be reticent if I didn't mention that today. I did put out a statement in my PCLOB capacity on X-Keyscore, which is an NSA program that was exposed 8 years or so ago. In that statement, though, I do have a substantial discussion of the legal concerns, particularly around the Fourth Amendment, that arise in a world when the vast majority of surveillance is done by machines rather than humans. And I think that presents fundamentally different threats to privacy and civil liberties, and also raises fundamental questions on the collection side and not merely the querying side with respect to the use of artificial intelligence, for example, and when that would trigger the Fourth Amendment. Typically, in the past, we've sort of had this humanized view of the Fourth Amendment rather than thinking when machines can actually trigger what constitutes a search. So while I agree with Bob that there have been some changes to the Fourth Amendment, relevant legal changes at the U.S. Supreme Court, as well as the federal appellate over the last years, I think it's absolutely critical that at each stage, the NSA, FBI, and other agencies are also considering those legal analyses and considering the way the world has evolved. And that's my concern, is that the reliance upon primarily Smith versus Maryland, 40-year-old case law to justify all, foreign surveillance in or through the United States might be a little bit dated and is no longer satisfactory in and of itself.
Charlie, can I just throw a reaction in here? I think Travis raises an excellent point about artificial intelligence. And I'd come at it from a slightly different direction, which is that given the volume of information that exists in the world, the intelligence community is going to need artificial intelligence and machine learning to do its job properly. Whether that be the issue of classification or declassification, whether it be the job of sifting through social media feeds, there's no question that this is something the intelligence community is going to have to deal with. But you're absolutely right that we need to be really thinking through the legal implications of this. There's a difference, I think, between using artificial intelligence to obtain information and using artificial intelligence to support actions. And the question is, can we devise a system that provides sufficient safeguards so we don't leap directly from a computer's conclusion to an arrest, to pick one example, without additional human intervention? It's a really significant legal question that needs a lot of attention, more than it's getting.
One quick here, picking up on Travis's mention of the statement he put out today about the still classified and perhaps never to be unclassified PCLOB study on the X-Keyscore system. That's the system that the NSA uses to search for and query data it has already collected, primarily under Executive Order 12333, which allows bulk indiscriminate collection as long as it takes place abroad, or if on US soil, if it's a foreign to foreign streams, raising questions about what the government does with Americans' data that gets inevitably from time to time swept in through that method. In his statement, he mentions that the PCLOB, when they launched this study, they launched it in 2014. In 2015, they asked the NSA for its legal analysis of issues related to the use of the X-Keyscore system. And Glenn, we were talking about this a little bit before the panel started. They were provided with a 13-page memo produced by the National Security Agency's General Counsel Office and dated in 2016. That's when you were the General Counsel of the National Security Agency, Glenn. And Travis raises the suggestion in his statement that there may not have been a legal analysis of X-Keyscore prior to that. It was prompted by the PCLOB. Then he says in a footnote that only this March, NSA said, well, there was some prior legal analysis, but the PCLOB has asked for it and to date has not been given it. Can you say whether there was robust systemic level analysis of legal issues raised by X-Keyscore prior to 2016?
Sure, I'm not so sure how big a issue this is in the grand scheme of things. I think a lot of things we've talked about early in this panel are more significant, but to get into this particular detail, I can assure you that there was a continuous and robust legal analysis of all of NSA's programs, and in particular X-Keyscore, when the PCLOB initiated this particular inquiry, which NSA and the CIA and others welcomed into Executive Order 12333. There were extensive discussions in late 2014 and 2015 before I got there, and then after I got there, on scoping the request, finding out exactly what information they needed. And NSA, in response to that, collected prior legal analysis and put it in a compendium in that 13-page memo you described. There was robust discussion of this. I might also add that during the entire 5 years I was at NSA, had there ever been any kind of even a hint or whiff of anything unconstitutional or inappropriate or excessive, not only would I have just sounded the alarm bell, I would have resigned immediately. And now, obviously, that was not the case in the remotest. I feel very comfortable about this. I understand there's some technical issues that people are looking at, but let's put this issue in perspective.
All right, I'm going to move now to a question from the audience. This is from Chris Ahoyan. He's an aide to Senator Ron Wyden and an expert in his own right on these sorts of issues. I'm just going to read what he wrote to you. The parts of our surveillance laws that get the most attention are those that regulate the circumstances in which the government can force companies to spy on their customers. But the government can also buy data. Your panel includes some of the top experts on surveillance law in the country. And so I'd like to hear their thoughts on an obscure section of US surveillance law added by the original FISA. Do the panelists believe that 18 USC 2511 2F permits US intelligence agencies to legally purchase and use without any supervision by the FISA court metadata about Americans' international communications, such as calls and texts and emails to family and friends abroad, and records of their browsing of foreign websites. Let's start with you, Bob, since the other two were just talking. Is that lawful? Without court oversight, can the NSA buy Americans' metadata from companies abroad, at least?
Charlie, I have to beg off on answering this one.
How about you, Glenn?
I'm not familiar with that particular section that's referenced right now. I certainly feel very comfortable in the layers of oversight that the National Security Agency is subject to, ranging from the Department of Justice to the Office of the Director of National Intelligence, to the FISA court itself, to the President's Intelligence Advisory Board, et cetera. So I believe there's very robust oversight of NSA. As to that particular statutory section, I don't have that at my fingertips, sorry.
Okay, well, maybe abstracting away from that statute in particular, Travis, unless you have specific thoughts about it, your thoughts on the law and what it is and what it ought to be surrounding intelligence agencies purchasing data rather than compelling the production of it about Americans.
Yeah, as a general matter, I do think that Glenn and Bob would be the better sources of information on that. I am, to provide a little background on it, I am generally aware of the Carpenter decision from the Supreme Court, and there's been this back and forth with DIA and Senator Wyden's office in particular about whether or not DIA should be able to, and the intelligence community more generally, should be able to purchase commercially data commercially. DIA has taken the position that Carpenter was a narrow decision that was not meant to include national security within the scope of the decision. There's some basis for that in the language of the majority opinion there. That being said, Senator Wyden has introduced the Fourth Amendment is not for sale act. I believe it's gotten bipartisan support, and it would limit the ability of the intelligence community to purchase, to make these sort of commercial acquisitions of data. It seems, it's been heralded by privacy advocates as a good path forward. In my view, from the PCLOB perspective, we're actually taking a look right now at the FBI's use of open data in its investigations. It's something that we've been looking at for a little while. It's something that I hope at some point in the future we'll be able to add to the conversation about. But it is, obvious that we're in a world now where there's a lot of data on each of us that is available on the open market for anyone to purchase. And the question then becomes, does the Constitution or law limit the US government, in particular the intelligence community here, from also purchasing and using that data in the absence of judicial oversight?
Bob, seeing where this conversation has evolved away from that specific statutory provision, do you have anything to add?
No, regrettably, Charlie, that wasn't my problem.
Oh, all right. The next question comes from Melissa Cooper. I'm curious about the panel's view on the government using corporate entities for access to data beyond cyber attacks. This is to find known criminals, and the friction between the EU, including Schrems II, and US surveillance practices. Would one of you like to tackle that?
Well, since I punted on the last one, I'll talk certainly about Schrems. As Glenn noted, I was deeply involved in the U.S. negotiating team that led to the Privacy Shield, which dealt with the Schrems I decision, which has now been struck down by the European Court of Justice in the Schrems
Bob, maybe
II
you should
decision.
briefly take a sentence to define Schrems and Privacy Shield.
Yeah, well, I would. That's good. If you go back 20 years, when the Europeans started instituting data protection regulations, a fundamental basis of their regulations was that personal data about persons in the EU could not be exported out of the EU except to a country that had essentially equivalent privacy protection. The US obviously has a very different legal framework. 20 years ago, they reached an agreement that was called the Safe Harbor that was approved by the European Commission as providing adequate protection. The Schrems decision struck that down, basically saying there wasn't an adequate basis for finding a privacy protection. So we negotiated the Privacy Shield, which again was an agreement where if companies agreed to abide by certain principles, they would, the European Commission found that the privacy protections would be adequate. In Schrems 2, the European Court of Justice said, no, not good enough. And they basically identified a couple of different problems. One was that there are certain kinds of surveillance in the United States, and they focused particularly on Section 702 of FISA and Executive Order 12333 collection, which has been referred to a couple of times, that those are not subject to adequate supervision and narrow legal frameworks to meet the European standard of necessity and proportionality. And the second problem that the European Court of Justice found was the unavailability of judicial redress for people who may think that their rights have been violated by surveillance, but can't prove it because they haven't been told that they've been the subject of surveillance. This is a basic framework of American constitutional law. You don't have standing to challenge actions unless you can show you've been harmed by those actions. But the European Court of Justice found that the availability of judicial redress was a necessary part of privacy protection. So I know that the US government and the European Commission are back in discussions about this. This presents a huge conundrum for companies because violations of the European General Data Protection Regulation can carry fines of up to 4% of a company's gross turnover worldwide. And so you're really taking a risk if you continue to use existing mechanisms that haven't been approved by the European Court of Justice. On the other hand, Glenn talked about globalization, and globalization of data is really essential to commerce now. There just has to be some sort of solution found that preserves this, but it's going to have to be a solution on a government to government level, not one that requires individual companies to resolve the question on their own.
Okay, I think we have time for maybe one last question here. This comes from Ash S. I have a suspicion about who that is. How does the technical reality that a great deal of US persons' data is now simultaneously stored domestically and in data centers abroad for data redundancy and availability reasons raise Fourth Amendment concerns and challenge the legitimacy of data collection under Executive Order 12333? This is part of what Travis was concerned about, I think, in the earlier discussions that Flicked at including in the X-Keyscore discussion. But maybe I'd like to start with you, Glenn. Do you think that this change in simultaneous storage and redundant data centers, both in US and abroad, is going to affect the NSA's Fourth Amendment analysis about what it can collect and where?
I don't really think so. I think the NSA is going to abide strictly by the Fourth Amendment and be very focused in the kinds of limited efforts it undertakes in regard to foreign intelligence surveillance. It undertakes a lot of effort to make sure it doesn't inadvertently come across Americans' data. And there's a lot of oversight that is designed to deal with that. So I think this is not so much of a Fourth Amendment issue as it is sort of a general policy issue. And one of the things that I'm particularly concerned about is that the private sector is amassing vast amounts of data that have relatively little controls over it. The Fourth Amendment, of course, applies only to government. We certainly need to be vigilant about government's efforts in this regard, but when we compare the amount of data that the private sector has and our notions of privacy, it seems to me that intersection is something that deserves a lot more attention than it gets right now.
All right, Travis, do you have anything to add on this? You're muted, Travis.
Yep, I will just add that I think the Fourth Amendment analysis too often turns just on target and not on location as well. And this highlights that in this new world, we can't assume that just because data is foreign, that it is unlikely data is located in a foreign jurisdiction, that it is unlikely to involve U.S. persons, and that maybe we need to start doing a more searching inquiry into the data that we have there to identify those sets that involve U.S. persons. That's a challenge. The massive amount of data out there that agencies like the NSA may have to digest makes it really difficult, but there are methods that could be taken to assist with either easily tagging data that becomes known to be U.S. person data, developing queries around it to assist with making it a little bit easier to track that. Finally, I think it highlights again the challenges of applying the Fourth Amendment in the 21st century world. And those kinds of legal questions are of the kind that the NSA, the intelligence community writ large, really need to grapple with to ensure that we're able to respect the privacy and civil liberties of U.S. persons in particular in the 21st century.
And I just want to add that I think we can all agree on that last proposition.
All right, that's a great note to go out on. We are at the 5 o'clock mark. So I'd like to say thank you very much to Glenn and to Travis and to Bob and to the audience, including those who submitted questions. Thank you very much for the few of you who submitted some questions we didn't get to. I apologize about that. We just are out of time. And so with that, I'd like to turn this back over to Chris.